Welcome to the Melinda Eitzen Show. I'm Melinda. Today we have with us my partner, Brittney Bramlett. Welcome, Brittney.
Hi, Melinda.
I'm so glad you're here.
I'm glad to be here.
We're going to talk about getting ready for trial.
Something I do all the time.
So, do you start the week before?
I mean, if you want to live in a land of anxiety and be unprepared for trial, but no, that's not really the right way to get prepared for trial.
So when does the preparation really begin?
So for me, the preparation begins on that initial consult with a client, right? If you're talking to somebody about how to best prepare and overall strategy in the case, I start discussing with the person on the very first meeting. We always talk about what's our worst day, what's our best day, and we build a case from there. So in my mind, though the hope is not to get to final trial and the hope is to settle somewhere along the way, my preparation starts immediately.
Yeah, that's good. And we have trial deadlines. Once the trial date is set by the court, certain things have to happen 30 days before trial, 60 days before trial, 90 days before trial, 120 days before trial. Are those real?
I mean, they're hard and fast deadlines, but again, not best practice. So one of the big deadlines we have is a 120-day deadline to start naming experts. But along with that just means 120 days before final trial, we have to name our experts, but we also have to tender our expert opinion. So if we're looking to hire an expert 120 days before final trial, well, the expert has no ability to make an opinion, and you've just lost that deadline. So if you're in a case where you need some experts, that preparation is going to start again at the offset, or if there's no hope of getting a settlement, 6 months, 7 months, 8 months, a year before final trial, you need to start thinking about that 120-day deadline.
And under the rules, the other side, you only have a right to 45 days notice of trial, correct?
Correct. And I find that in a lot of the smaller counties in Texas, the courts will give you that 45-day trial deadline, and you have no opportunity to start naming an expert or meeting any of those 120-day deadlines.
So you can't sit behind the log, so to speak. You got to get busy as soon as you're hired in case you are going to need to have experts, and the expert might need some documents.
And if we're going to get those documents, we have to go seek those documents through the discovery process.
If they're from the other side, or if they're from a third party, like an employer, then how long, like let's say I send a third party subpoena to the employer and say, hey, I need to know all this guy or gal's benefits. Because people, in my experience, don't always even understand their own benefits. And they don't really need to. They just know someday I'm going to get a pension or whatever. So relying on them to give it to us isn't always great. And I like to send a third party subpoena. But if I'm going to do that, how far ahead before I expect to get those documents do I have to send that request?
I mean, again, I think you're looking at best practice is going to be 9 months before trial. So I'll give an example that's not related to finances. CPS records. I mean, CPS records, you have to subpoena. They believe they have 45 business days to tender any of the documents to you. So that could be 60 days of calendar days ahead of your 120-day deadline that you might want to give those CPS records to your expert. So if you're looking in a case with one of those types of statutory deadlines, you really have to be thinking about this a year before, and you might not even know when your trial is when you need to start sending those third-party subpoenas.
Exactly right. And you practice in what counties, Brittney?
So I'm all over the place. I mean, we're headquartered in Dallas, but I have cases in Collin, in Denton, in Hood County, I'm in Ellis County all the time. I'll be there this afternoon. I even have cases down south of Austin. So I think I'm an equal opportunist with the Texas judiciaries.
And it's really sometimes county driven, or it could be court driven. I was shocked last time I was in Tarrant County on a case, and they said the first trial option I had was a year away. And I said, excuse me? Because in Dallas County, in Collin County, where I am more often, you can get a trial much faster than a year. And they said, no, that's the first choice, a year from now. So some of it is knowing your county and how it runs, right. How quickly or not you need to be asking if these people do want to get divorced. But I'm not always eager to go request a trial date if I need to do all the things you're talking about, because if I'm in a county where they're going to say 45 days, I don't want to start that time ticking.
Right. Well, and you have so many of these cases where you'll get a client and their emotions are charged at the beginning of a case, and there's no settling, there's no compromise. But once that 60-day deadline starts to run, the 60-day deadline of the cooling off period required by Texas, I oftentimes start to see some of the emotions drain from the clients. They're more willing to be reasonable. They start to have an understanding of how much it's going to cost to start chasing bad money with good money and seeking some documents that might not pay off. So a lot of times, in my experience, the really emotionally charged cases might die down before you're even looking at the trial setting or before you're looking at subpoenaing some of these documents.
So we're running 2 tracks all the time, right? The settlement track and the get ready for trial track. And you can't really pause the get ready for trial track completely while you're running the settlement track.
Exactly.
Because you don't want to be in a position where, it didn't settle. I thought it would. Now I'm not going to be hitting my trial deadlines.
Well, and a lot of the counties I'm practicing in have the requirement to go mediate a certain amount of time prior to trial. So Dallas will now have you, some of the district courts in Dallas, they want you to mediate before you can even get a trial set.
Yes, I thought that was interesting. They said, don't mess up my docket. Well, they say 85% of cases settle. So that's smart from a judicial standpoint. They're like, why do I want 85% of the cases on my docket to be fake?
Right. But Melinda, I was in trial last week on a case that had mediated the week before, obviously did not settle, but
it might not have been ripe.
It was well, the case had been pending for a significant period of time. We got ordered to mediate again the week before trial, and that was almost
might have been too ripe.
It did present some issues that did show up at trial that we were able to do some free discovery on that otherwise that was a little bit of advantageous. But we were sitting in the mediation arguing about case law that was black and white case law, and we ended up going to trial anyway. So I guess it depends, like you said, on the counties that you're going with and how your preparation starts, where it never finishes until it's over. But, what steps you're going to take to lead up to that culminating event.
Mm-hmm. You're a mediator like I am.
I am.
Younger, newer to the mediation world, doing great though. So there is a tension on when the best time is to schedule the mediation.
Yes.
Too early may not be ripe. And what I mean by that is the theories of the case have not been developed enough for people to see with their risk. And they're still fighting mad, or they still have a lot of energy for this case. They think they want to go fight it out. But if you're too close to trial, like you just described, then they're not getting the benefit of settlement. The one benefit of settlement, which is we don't have to spend more money getting ready for trial. They've already spent it. If they're a week away from trial, you're pretty much already ready.
Exactly.
So there's someplace in the middle there where mediation it's the best timing, right?
Right. And every case is going to be different. You have to look at fact specific. What are your issues? Who are your witnesses going to be? Who is your judge? I mean, one of the counties we didn't talk about is Collin County, who wants you to file and conclude a case within 1 year, which you're going to be timing your mediation of when you're going to be scheduling that differently than on the cases like in Tarrant County, where your trial setting is a year after you request it.
Right. Your case could have already been going on. And that's important to know if it's important to your client to be done by some specific time. You might have to ask for that trial date in Tarrant County earlier than you would ask for it in another county, because it's going to be so far out. And we're speaking generally. There might be specific judges in any county who do things differently, but that was my last Tarrant County experience, where I was like, what? A year? Excuse me?
I had one of those in November.
Okay, so we've talked a lot about things the lawyer needs to think about, deadlines we have to hit. But one thing that I've observed is many people underprepare the client. And what does your client preparation look like? How do you prepare your client for testifying, for example?
So I like to have open conversations with the client early. What are your goals? Let's talk about how we're going to get the information that you want to support your goals. So we have to start thinking about admissibility. So I'll have a client that says to me, my neighbor is going to testify that the child said to her they want to live with me. Well, we've got some evidentiary problems here, right? How we start talking with the client. Well, if that is the belief, we can talk about that outside of court, but we obviously can't have the neighbor testify about hearsay of the child. We've got evidentiary issues everywhere. So what I like to do is get the big picture from the client first, then start mapping out, here are the 5 goals I took from the client. What sort of evidence do we need to get there? And so I'm not really one of the attorneys that start drafting questions to read to my clients during trials. I know that a lot of our trial attorneys are. I've never really been that great at that. But if you get the outline sketched, then you can start to decide what pieces of evidence are going to support what you want from there. Start building out the evidence. This document's going to support that. This recording is going to support that. And then you have to work with the clients on making sure that they still believe that statement. I could ask the question to support the legal theory. And if the client doesn't quite understand where the questions are going, as they don't, because most of the time they're not lawyers, we're going to have a testimony problem. So I like to educate my clients and let them know, here's why I'm going to be asking some of these questions. This is just the flow of our testimony here. So if the trial I had last week, we have some very specific goals we needed to accomplish regarding ownership of a house. This was one of those situations where we drafted the questions, we rehearsed them, we showed the evidence and the documents that were going to support what we needed to show in the law for the court to rule the way that we were requesting. So in those scenarios where there's something that's very legally specific, I will run and rehearse and practice those questions. But that's not always the case in a custody situation because so much is up to the fact finder and so much is best interest standard, which can't be defined as easily as property.
So practicing with the client is important. And it's not because we're telling them to say something that isn't true, right? We're starting with, hey, just tell the truth. But the problem is it's not a natural conversation in court. There's rules about how they have to answer, what's responsive, what's not responsive. They're going to have people objecting and that'll shake people up, right? They need to be prepared for that and know that, hey, if the other side asks you a direct question that's yes or no, you can't go tell them how, if they say, what time is it? You can't tell them how you made the clock.
Right. And that's everyone's defense, especially when they're being questioned by the other attorney. They want to be able to explain more. It's not natural to have that just yes or no. Well, and another thing I think is important to practice is when the attorneys start objecting, the clients don't know to stop talking. So they keep answering. The attorneys are yelling. The court reporter's giving looks to everybody and the judge gets really irritated. So we don't want to have our client be the person that's irritating the judge who's about to make all these decisions.
Right. So you have to take enough time to practice that. And my philosophy is they're not going to capture it all in one sitting. So I usually set one practice session maybe a week or 2 before trial, and then a second practice session maybe a day or 2 before trial. So they have time between those sessions to kind of adjust or at home reflect on what I taught them in the first session. And then the reason I like to do a second session right before trial is then it's super fresh for them. And you can tell the truth well, or you can tell the truth not very well. So I want them to tell the truth the best way possible. One, we are very time limited in some of these counties. I mean, we have one judge in Dallas County where I don't even know how to explain how time limited we are. They can't, go around the world 10 times to answer a question. We've got to get it quick, but not so quick that the judge isn't getting a flavor for them, especially on child cases. You want the judge to be able to see this person is a caring parent. They care about their child. We want them to have a moment to explain, what's their child like? Oh, little Johnny, he's so fun, we have fun doing blah, blah, blah. So you want a little warmth also, but you cannot have them rattling on about 5 different things that weren't answering the question, because how are you going to get the rest of your evidence on? You don't have time.
Especially if you have a nervous client, and everybody is nervous by the time they get up there.
Yes. So I think that's a good philosophy is, hey, give them more than one practice session. And I've been, in court a lot in 31 years. And sometimes we're waiting our turn and we're watching other cases, right?
Right.
And so you see the mistakes of others, which you can learn from. We can all learn from each other. But my biggest criticism is people are not preparing their clients and they do not know what their client's going to say. And then it doesn't matter how much lawyer prep we do. We hit all our deadlines. We got all the discovery. If then our client tanks the whole case because they said the wrong thing. And I've had my own client say to me later, why did I say that? I didn't mean that. That's in depositions too, right?
Of course.
Like, why did I say that? I'm like, I have no idea. I didn't tell you to say that.
All the prep in the world.
So one thing that I always tell clients is you are going to be worrying about something they're going to ask you. And you're going to have a temptation to blurt out that answer when they didn't even ask it. That's a natural phenomenon. So don't do that. Like, really listen to the questions. It's okay to say, can you repeat the question? Because they're nervous, right?
Right.
And they don't know what the person just said to them, but they do know they're worried that they're going to say, what did you do on February 14th at 3 p.m.?
Just don't know.
And they're going to blurt it out.
Well, and hopefully they're not volunteering to say, well, I can get it. I can answer that if I can have access to my phone. No.
Right. So we have to tell them that stuff, right? So there is client preparation time. And I think lawyers can be so busy. We're going from, trial on Monday, mediation on Tuesday, so on and so on, that we forget to block our calendar to have that preparation time. So that's something our paralegals could help with. Paralegals listening, like block time for the lawyer. And if it's a client listening of anybody's client, you can be the squeaky wheel and say, hey, I need more prep time. I want prep time. I want on your calendar.
Well, and some clients are just not as natural as others on the witness stand. And those are the ones where they typically have a lot at stake, where they need a little bit of extra practice or brainstorming.
Yes. Okay, let's talk about other types of witnesses. There's a regular witness and an expert witness. Do we prep them? How does that work?
Some of your expert witnesses, they'll prep you. In my experience, they know exactly the information they need to get out, and they will tell you how they prefer to get there. So those are some of the easier expert witnesses. And a lot of the ones that we regularly see in family law cases.
Give an example of a type of expert that you're talking about.
So let's talk about a forensic psychologist. And the forensic psychologist has spent their time in preparation reviewing and analyzing a custody evaluation.
Okay.
So now we are talking about two mental health experts involved in the case. One who is boots on the ground, interviewing the children, reviewing all the documents and the letters from the teachers and all those other documents that a court cannot necessarily consider. Mm. You then can potentially hire an expert to critique the custody evaluation.
Because you didn't like the result.
Of course you did. Or there was one, Melinda, I did in August where I hired an expert to support the custody evaluation.
Oh, that's interesting.
I was so nervous that the other side of my case would be able to poke so many holes that I had hired a second forensic psychologist to say, here are the proper procedures to conduct a custody evaluation. Here are the ones that were done correctly, right? It's not credible if you have 100% of right on from your hired expert. So, in that situation, we had a forensic psychologist that said, here's a couple of things that would have been different and may have led to a different result. But overall, we likely were to have ended up exactly where we were because here's the procedures and here's the steps that were taken and here's what was followed.
Interesting. Okay. So that when you had that psychological expert, they're an expert. They're not just a witness. An example of a witness could be a friend, a neighbor, a coach.
Of course.
The treating therapist may not be an expert. They just may be there talking about they saw the child and this is what is going on.
In some of the ones that I struggle with the most are the most important experts that we have in a case or even just a witness. So when we have a parenting facilitator that that person's entire job is to be unbiased and to be equal and to have equal conversations with both sides, we're not really able to prepare with that witness and say, these are the questions I'm going to be asking, because in order to maintain their own integrity, they don't want to have a conversation with just one lawyer.
Mm-hmm.
That's the easiest cross-examination. How many times did you prepare with Brittney?
Right.
So these are situations where you have an idea of what they're going to say, but sometimes that's based off of feedback from your own client who's sitting in those parenting facilitation sessions. Oftentimes it is a surprise. So in those situations where it's the policy of the witness, whether a lay witness or expert, to not do those prep sessions, trial becomes a little bit more, again, surprise than trial attorneys necessarily enjoy.
Right. So if you have a witness, like let's say a coach or a neighbor, are you interviewing them in advance?
Yes, at all possible times. Again, like we were talking about a little bit ago, sometimes time prevails, or in family law, all these facts evolve constantly. They're happening in live time. So when you have a coach that's going to come testify, he might have relevant information that happened 2 days ago, and you've already done the witness prep and the questioning and the outlines. So there has to be some flexibility involved with these witnesses too. But I do talk to them before. Same with the clients. I like to hear their story first, so it seems more natural when they're talking about it on the stand. And if at all possible, I can try to shape my questioning around their truth.
You definitely, in my opinion, have to interview anyone who will allow it. Some won't. Now the schools have gotten really protective of the teachers, and they won't always let you interview them anymore. So you just have to call them and hope for the best. But if you can get to the witness, your client's perspective might not always be accurate about what that witness is going to say. People, they don't tell people if they don't like them or if their opinion is negative. So I want to interview them and make sure they're going to be a good witness for my client and not be surprised that I called a witness who hurt my case. So I like to interview them. And then I find if you can and you have time, if you can just write the few questions, these aren't going to be people on the stand for hours, right, but write down the few questions in advance, not with the answers, just the questions, and send it to the witness in advance. That just makes them feel a little more relaxed. Oh, good. This is what you're going to ask me. I usually say, I'm going to ask you what I just asked you, in our interview. But if I can write them down and then they can say, oh, good. But you have to keep in mind that could be revealed to the other side.
But it also, these types of witnesses, the coaches, the teachers, the lay therapists, they're oftentimes asking us what the other side's going to be asking.
Right. And we don't know, but we could guess.
Right.
They're going to say, no, didn't you really see it the other way? Isn't their client horrible? All of that. But that is an interesting part of prep, and it takes time, and, you're having to manage with other people's calendars.
Right. And preparation for what the other side may think, feel, and hints you've gathered along the way is crucial to that sort of preparation with 100% of your witnesses, with your exhibits, with your evidence. Do you have a hint that there's going to be an accusation made at trial where you have the opportunity to prepare an exhibit that will debunk that? I mean, I worked in sports before as a lawyer, and we would always say defense wins championships, and, that sort of preparation, it needs to be considered.
Absolutely. Okay. You mentioned earlier that when we have to designate experts, which is either 90 or 120 days, let's say 120 days for purposes of this, that it's not just, this is the thing I think we see in the mistake so often, is you're not just supposed to say, Susie Q is my expert. You're supposed to say, Susie Q is my expert. This is what Susie Q is going to say. And here's Susie Q's report.
Right.
So very few people do that.
And especially when we've got some of our counties that want you to go be done with trial within 1 year of filing. Susie Q is making their opinions right out the gate.
Yes, before anybody's had time to give her anything. So that's hard to do. But if you fail to do that, this is a little practice tip. The other side could ask the court to not allow your witness, your expert's testimony or report.
Right.
That's pretty horrible, because you paid this person money. Your client has paid this person money to do their report, to show up for trial. If they're excluded, That's also a big mistake, because I don't see a lot of people try to exclude based on that.
Or they'll try to exclude at the trial setting, which at this point, I mean, you've got some on the ground trial options to take there. I mean, you could file a motion for leave ahead of time if you know you're going to have sort of a late designation, and just explain that this isn't going to prejudice the other side. The remedy for that is to continue the trial. So nobody really wants to do that, including the clients.
Yeah, you can. So to your point, a motion for leave would mean, hey, judge, I'm telling you, I can't hit this deadline, the 120. It didn't work with all the things that have happened, which were outside our control. Oh. That is not possible. So we want leave to file it late.
Right.
But to your point, not surprise late, not the day before trial, like they would still have plenty of time to review it. They can then designate their expert late. So there's remedies if you just plan. Like, don't just do it wrong and then wait to trial and then they say motion to exclude. You're like, oh, I should have asked permission to do it wrong.
Well, and not to overcomplicate, our lives as trial attorneys, but if our deadline to supplement discovery is 30 days before a trial, and 30 days before trial, you get these documents that are explosive that your expert needs to review and analyze and are wholly relevant and is going to change their expert report, sometimes our hands are tied, but this is where we can rely on some of these other mechanisms to just ask the court to either allow us to amend the report or move the trial setting, which, again, the clients rarely want to do.
And moving the trial setting is to give people time, because all of these rules are so that the court has the most reliable information and that nobody is surprised. Both sides have had a chance to review it. Their experts had a chance to do their thing. That's the goal, so we can have the best trial possible. So that is a remedy, is, hey, we just push the trial. That gives everybody more time to do what they need to do.
And hopefully you're not a year out, as in Tarrant County.
Right. When you start. Now, what does that mean? Do we come back in another year? Hopefully not. Hopefully they have room on their docket to just push you 30 days or 60 days, something like that. But continuances are not unusual in all areas of litigation. In some places I've even heard judges say you kind of get one free continuance for any reason. Depends on the judge. Newer judges are less likely to give you a continuance. That's always been true. I think it's because my theory is the new judge doesn't want to appear to be getting pushed around or something. So they're like, no, everybody's going to trial. I always think, didn't you just practice law? Don't you remember that sometimes we need a continuance?
Right. Well, or develop a theory.
Yes. So it's not easy, the work we do.
I wouldn't say so.
But it's rewarding, because we're really helping people through a hard time, and we want to do the best for them to show the court everything that needs to be seen.
Everybody deserves their day if they want their day.
Yes, exactly. Now, we're both mediators, so we also think everybody should settle. Most people should settle. Get busy getting ready for mediation. That's a whole nother, we'll do another one on that, is how to get ready for mediation. But it's similar. You want to get ready enough that you can enter into a durable agreement that people will both stick with.
Well, or at least narrow out some of the topics that both parties seem to be on the same page about. Why spend the precious trial time talking about something that the other side isn't going to challenge?
Mm-hmm. Are most trials in family law an hour, a day, 3 days, a week?
I think it depends on the issues, and it depends on your court. We do have some judges in Dallas that are going to give you 30 minutes to try a case that may be extremely complicated and have multiple property claims and multiple children. But in some of the smaller counties, I've got like I said, I take some cases down, as I call South Texas. I don't think it's actually South Texas.
South of Dallas is what you mean.
South of Ellis. Let's go south of Ellis. But I mean, I've had a 3-day temporary order hearing, which is unheard of where we are regularly. So again, that's something to either find a local counsel or poke around a little bit to figure out how much time you're going to have. Ellis County they'll say, how much time do you need? And if you need 3 days for final trial, we'll get 3 days for final trial. That's not always an option everywhere. So again, that's why it's important to start narrowing the issues. If there are things that are agreeable, or prioritize. I mean, we have not talked about prioritizing in a final trial. Everything could be at issue, but if you've got 4 hours, 2 hours aside, including cross-examination.
What's really important?
What's really important.
It does make you focus on that.
Sure does. Well, and sometimes you need the background of the things that aren't going to affect the property division, but you have to establish the pattern and practice of the parties.
Mm-hmm. So what's the best way for someone to reach you, Brittney?
Well, I can be reached by email. Our emails are listed on our Duffee Eitzen website. You can give the office a call and somebody there will get a scheduled appointment. Would not really give my cell phone number out to the podcast public, but I'm happy to talk to anyone that reaches out to me in one of those ways.
That's great. Thank you so much for being here.
Thank you for having me.
Hopefully people feel a little bit more prepared for trial. I think the key theme was start from the beginning, prepare ahead, because you can't wait till last minute. You'll just lose a lot of your best options for trial. Thank you so much for tuning in to the Melinda Eitzen Show. We'll see you next time.